Call the second case on this morning's docket. Case number 113165, State of Kansas v. Robert Doles.
May it please the Court, Caroline Zaschuk of the Kansas Appellate Defender Office, here on behalf of Appellant Robert Doles. If I may, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Briefly, we got to this point because my client was pulled over driving a green Chevy Blazer with Missouri tags because a car similar in description had been seen leaving the scene of a bank robbery the day prior. He was then detained by the officer. His car was ultimately searched and a large quantity of methamphetamine was found. He was convicted. He moved to suppress the evidence, but the court admitted the evidence at his trial. He appealed, arguing that the district court should have suppressed the evidence, and the Court of Appeals found that the evidence was permissibly seized and that the detention of Mr. Doles, my client, was reasonable. He then petitioned this court for review, and that's how we got to where we are now. He raised 3 issues in his brief: the suppression issue, the issue of whether he should have been granted a new trial based on newly discovered evidence, and whether the district court erred by giving the jury a preliminary instruction that advised them that a mistrial would be an inconvenience and burden to the court, the parties, and the taxpayers. I plan to spend the bulk of my time on the first issue, but of course I welcome questions on any issue at any time.
As you discuss the first issue, would you please describe for me the container that the digital scale was found in and its location in the back seat? What was it? There's a variety of different descriptions, and I want to get from you what you believe is the accurate description of what it looked like when the officer was peering in through the window or going through.
Well, 2 of the 3 times that the officer testified about it, it was a black case that he thought might be a digital scale. It was about 4 by 4 inches, like a cell phone size, I would guess.
Was it introduced into evidence?
It was.
Is it in the record on appeal?
It is not, to the best of my knowledge. Typically, I don't know if we can request physical evidence, but I guess that would be another matter. At any rate, it was introduced into evidence. 2 of the 3 times the officer stated it was an opaque container. During the mistrial, he did state that it had a clear plastic lid. I think while it would be helpful to have it in the record, even if we assume that the worst fact is true, which, to be honest, I'm not sure this court even considers because it wasn't before the court when they denied the motion, still it was within the judge's knowledge when he was hearing evidence at the second trial. So I'm just not sure how that procedurally affects which facts you take into consideration. However, even if we assume that you can properly consider it and that it was an opaque lid, the officer's testimony is still pretty clear that when he saw the container, he didn't immediately know what it was.
He used the word immediately. He said did not immediately know what it was.
Exactly.
Okay. All right. And where was it on the back seat?
It was
part of the question.
So when Schmidt, who was the backseat passenger, was removed and arrested pursuant to a warrant, it was where he was sitting or within. It was revealed once he was removed from the car. It was not obvious before that point in time.
So we don't know whether it's close to the window or in the middle seat or whatever.
It was where he'd been sitting, so no, I couldn't say more specifically than that.
Can I return back to that procedural point you discussed? 'Cause
Yes.
I'm a little confused by exactly what the sequence of events are. We have the first trial starting without a motion to suppress, correct?
No, the motion to suppress was filed before the first trial.
Okay, because there were some things that were said that made me think it maybe was in the second trial only. Okay, so it was the first trial.
Yes.
But there was no pretrial hearing, no
There was
evidentiary
not.
hearing on it. So, and there's a ruling at that point. Is it renewed then at the start of the second trial?
There was no pretrial ruling about the motion
Before the first or the second trial?
before either trial.
It wasn't ruled
It
on
was
until
done
after
in-
the state's
yeah.
case in chief, right? Is that right?
What I understood from reading the record was that the court reviewed the motion at each point the evidence came in. And the defense attorney below, so the state moved to admit evidence that Mr. Doles opposed. Defense counsel objected. Each time the district court overruled the objection. And that's about what we have.
So did this judge at any point say, had this judge even conducted the preliminary hearing? Was the judge considering evidence from the preliminary hearing?
Yes, that was what defense requested when they filed the motion. The state did not file a response to the motion.
So what do we look at as looking for?
And I looked for precedent to give you insight into that and couldn't find it. It's pretty rare that there's not a suppression hearing of some kind, or at least a pretrial, here are my general rulings. And so then I questioned, well, whose responsibility is it to get that? And the statute, which is the motion to suppress statute, I have somewhere in here, basically puts the burden on the defendant to file the motion before trial. That was done. It appears to me from the record that...
And we require that you renew the objection at trial.
Right.
And part of the rationale for requiring a contemporaneous objection is that the trial judge should be allowed to rule on it with the evidence in the context of the evidence that's come in at trial.
Precisely.
And if we say we can't look at the trial evidence, then why are we making the contemporary objection requirement? So it would seem to me that if we're going to require it so the judge can look at everything at that point, that's what we would look at.
Of course. And my apologies if I was unclear. I meant that I wasn't clear if the court could look at the evidence that came in at the mistrial.
Oh, okay.
I think you absolutely can look at the evidence that came in at this trial.
It was the testimony about the clear cover
That
that came
was-
in later. Is that specifically what you were referring to?
That testimony and the fact that there was a white getaway driver were only testified to in the mistrial.
So the procedural question that you were at least raising earlier is, could this court consider
The
those pieces
mistrial.
of evidence?
You saying mistrial, but do you mean the motion for new trial? Or do you
No.
mean when they declared the mistrial on the first trial?
I'm saying the whole first trial happened.
Yeah.
It resulted in a mistrial.
Okay,
At
right.
that trial, Officer Mance testified that there was a white getaway driver
Okay.
and that the lid of the container was clear. That evidence was not put forward in the preliminary hearing, and it was not put forward at the second trial. And so I wonder about and speculate about the evidentiary value of those facts when each time, if the defendant has to renew the objection each time the evidence comes in, theoretically the state bears the burden of establishing its validity each time it
So
comes in.
basically the question is it a blank slate when the second trial starts? Or do you get to import even
Right.
implicitly that's
Right, and our position is we win either way, of course. But obviously the facts are even more favorable to Mr. Doles if those two particular facts from the mistrial are not counted in the calculus. And I don't know the answer. It was just something that I wonder about and wanted to point out to this court, because when the Court of Appeals issued their decision, they talked about the clear plastic lid and they talked about the white getaway drivers, but those weren't things that actually came out in the trial that resulted in the conviction or the preliminary hearing on which the motion to suppress was filed. However, the same judge did conduct all three, so theoretically he knew this, and I don't think he has to ignore evidence, and the mistrial is part of the record, so that's where we are with that.
So the white getaway driver didn't come out in the preliminary hearing?
No, it didn't. And that's relevant because in the original trial, when Mance testified on cross, he asked, well, when you approached the car, did you have reasonable confidence that these people were not involved in the robbery? He said, yes, I had some confidence they were not. And defense counsel asked, because the suspected perpetrators of the robbery were black and the men in this car were white, correct? And he said correct. And he didn't elaborate further. There was no redirect. That was what was said. So it's our position that when he saw that all of the men in the car were white, whereas the perpetrators were black, and when he testified that he had some confidence, whether it was because of their race or some other factor that he knew about the robbery but did not testify to, that they weren't involved, that's when the stop should have ended. The best case to support that is probably State versus Diaz-Ruiz, which is a published Court of Appeals opinion, which does a pretty good job of explaining 10th Circuit law on the issue. In that case, there was a ladder that the officer believed was unsecured. When he approached the car to talk to the driver, he felt the ladder and realized it was secure. He then went to the front of the car, asked the passenger and the driver for their IDs, ran a warrant check on them, eventually obtained consent to search, and found contraband. And the Court of Appeals reversed, relying on 10th Circuit law, saying when you stop someone for any reason based on reasonable suspicion, the duration and the scope of the stop have to be tied to the specific purpose that justified the stop.
And you're saying that the fooling around in the console wasn't sufficient for reasonable suspicion?
The officer didn't testify that made him suspicious. Had the officer testified, well, I approached them about the bank robbery, and then on approach, I developed reasonable suspicion some other activity might be afoot because they were rustling around, we might have a different scenario. But here the officer testified, I approached the car, I didn't see anything illegal when I looked in the back. I recognized two of the passengers. I didn't believe these were the guys. I had reasonable confidence they weren't the robbers. And then he asked for their IDs. Then he ran warrant checks on the driver and all the passengers. And this proceeded into quite an extensive stop and search.
Before you run out of time, I want you to talk about the entire car search, both consent and the probable cause with exigent circumstances within the scenario that this guy is arrested.
Yeah, so we obviously believe that we believe that the scales were not in plain view because the officer said, as Justice Beyer pointed out, that he didn't immediately know what they were. It's possible the lid was not opaque.
Okay.
But
you're arguing there wasn't probable cause.
No, there was not probable cause.
Okay, but could they impound the car? They have arrested him.
They arrested the backseat passenger. They only arrested the driver after they searched the car and found the contraband. So no, they wouldn't have been able to impound the car based on the arrest of the backseat passenger.
And his consent was involuntary because the officer says I can get it, I can search anyway? Is that your
Yes,
argument?
that's one reason, and the other reason is that he was illegally detained at that time. So there's two ways that you can find that the search was...
Well, what part did the possession of the scales play in the consent? As I understand, the scale was seized. The officer learned that they were scales. How much of that was a part of the discussion on consent?
Significant, because prior to that point in time, Officer Mance testified he didn't believe he had cause to search the car. After he found the scales, then took them out of the car, then opened them, which we argue is, of course, another Fourth Amendment violation. It's once he confirmed that they were, in fact, scales that he believed he had probable cause to search the car. And since he never should have opened the scales in the first place, we don't think that should factor in. But even if this court disagrees and said, okay, you can look at the scales, we still don't think the totality of the circumstance supports a finding of probable cause in this scenario.
How much, though, didn't your client give consent to search the
He
car?
did.
How much a part of that consent, that discussion, included the existence of the scales?
Well, the officer was like, I believe I have consent to search because I found these scales and they're commonly used in drug trafficking and because I saw you leaving a known drug house.
Had legal right to search,
Right.
not consent.
Right. Sorry, thank you. Yeah, I believe I have
Based
the right to
upon the
search your
presence
car.
of the scales, and so then he ultimately said, okay, go ahead and search.
Right. And at that point, there was already a demonstration of authority which suggested that he didn't have the right to refuse. Thus, the consent wasn't voluntary.
Didn't he say
Have you-
something to the effect, do what you have to do, or something like that?
Right, like, do you really have to do this? And the officer responded, well, I can. And he's like, well, do what you have to do. Absolutely.
My reading of the Court of Appeals opinion indicates that they did not address the consent issue. Is that right? They
didn't, because they found probable cause existed regardless of consent.
And was that an issue you've petitioned us for review, the consent?
I believe so. But I can check my petition and get back to you in rebuttal.
All right, thank you. Any more questions? Thank you, counsel.
Thank you.
May it please court. I'm Todd Thompson. I'm the county attorney for Leavenworth. I appear for the state, as well as being the appellee. I believe you heard some of the facts. The state would actually believe that you can look at all the elements that had come forward. It's our understanding that there was a pretrial hearing, then a motion. There was the mistrial and the trial. In the trial, both.
What's your authority for we can look at all of the record here?
Like I believe you can. I believe that's the way the Court of Appeals reviewed it. I believe it was brought up in that fact. As part of the record of the case, I believe the suppression issue occurred both in the mistrial.
And we had the same judge for the mistrial, and
Correct.
And so if there was a different judge, could you still do that, or?
I believe it would be readdressed, but I don't know.
Was the motion to suppress refiled
I'm not
before
aware.
the second trial?
I'm
Do you
not
know?
aware if it was, or I don't know how it was brought back up.
So there wasn't a blanket agreement like sometimes there is on a mistrial that any prior motions or any prior rulings on motions will carry forward to the second trial. Nothing like that in the record.
Precedence in our district is generally whatever happened through the mistrial continues to carry on into the trial, and that's how we've handled other cases.
Okay, but the record here may not necessarily be very clear about that.
No, I don't know that they made a fair record on that. I'm not
Okay.
aware.
Well, if the box is in the, the box for this, with the scales is in the record, just tell us, what's the lid? Is it clear or black?
It's a clear lid. It's a black box. It's open.
Black with a clear lid.
Correct. Plastic. 4x4.
And the officer testified when asked whether he knew it was digital scale. He said not immediately, but I suspected it to be a digital scale. And at one point he says that he knew then when he opened it. Do you disagree with that?
No, that was in the statement in the pretrial. Let's see. That was in. He stated that in the prelim. He said that.
And one of our requirements for plain view is that it must be immediately apparent that it's the incriminating character has to be immediately apparent.
By probable cause, correct.
And the officer said it wasn't immediately apparent. He just suspicioned. So how does that fit?
I believe he said by his training experience that he knew it to be a scale. By the time he picked it up and then opened it up, he was verified, or 100% it was a scale. I believe with the significance of the facts that were laid, the fact that Doles had already made an admission that he was at what the officer knew to be a drug house the night before, that the officer had witnessed him come in what he known to be a drug house, and the fact that the officer knew the other occupants to be.
Well, I understand all the things that would lead one to suspect, but it was my understanding that plain view means observation. You see something, and its incriminating character is immediately apparent from your observation, not from having gone to the law enforcement training center or being trained in drug interdiction or having been observing drug house or whatever. Plain view is plain view. And so I don't know how you can say this fit within plain view if the only way he knew that it was incriminating was through training and prior observation of a drug house and that sort of thing.
Well, and in the mistrial, he did note that he saw what he saw as a 4x4 new plastic lid, and concluded that it was a digital scale by its look and presence. I believe when he said, and I can't speak for him, I believe what he saw with his training experience was a digital scale, and I believe the way the testimony that came out was by the time he opened it up, he was 100% certain it was a scale, but by probable cause of the circumstances surrounding that, he knew it to be a digital scale.
So you're saying that if a trained officer looks at something and through training has probable cause to believe that it's a digital scale, that fits the definition of being immediately apparent, that its incriminating character is immediately apparent?
I believe what he saw immediately apparent to him is what he felt was, by probable cause, was a digital scale. I believe that once he opened it up, he would be able to, without a doubt, know that it was a digital scale.
But a step had to happen in between there, and that was reaching into the car and grabbing it. So let's try and break this down a little bit farther. I think you're trying to rely on plain view for him to be able to take that out of that car. I think you got a problem with plain view because he testified not immediately obvious to him. So, I mean, you're kind of out of plain view territory. So let's just assume that for purposes of argument. Could he go in based on probable cause plus exigent circumstances? Could he pick it up because of that?
I do believe that he could. I mean, I believe in the totality of what he saw. I believe that when you look at probable cause, you look at it in the totality, or the case law says that you look at it in the totality of the circumstances. And the totality of the circumstances is the fact of the things that I listed before.
Then you can consider all of those other things.
All
you
those
attempted to
factors,
list. They're irrelevant to plain view,
Correct.
but they're relevant to whether you have probable cause and exigent circumstances to snatch it up at that point, right?
That's what I believe, yes.
Okay, thanks.
In regards to the extension of the stop, since that was mentioned before, it was actually mentioned not only in the mistrial, but it also was mentioned in the, I believe it was the prelim, that there was a white male that was a driver. The laws that the appellant rely on are all regarding traffic-related stops, regarding to some type of traffic offense in a level 8 KSA. This was something different. This was a suspected robbery of vehicle, matching the car description, matching a license plate, and there was a white driver. I believe they had a rationale to be able, through the totality of the circumstances, to be able to review that and look into seeing, at least checking the ID. The fact that Doles did not have an ID.
And that's all a necessary prerequisite to what you and I just discussed, right?
Right.
He has to be they have to all be lawfully detained. He has to have a good reason to be checking their IDs, to arrest that guy, etc. All of that has to be kosher before you get to grabbing up the case,
Before
right?
to get into the vehicle.
Okay.
And in fact, they found that the passenger, the rear passenger was the one that had a warrant, and his arrest caused what they saw would be the scales, or he saw.
But the real critical fact for all of that to be okay
Correct.
is the white driver.
Correct.
That's really the fact.
Correct.
And so we have to decide whether we get to consider that.
Correct.
And the record's not abundantly clear on how that gets considered.
Well,
is it?
actually, the trial actually said there were two black males, and And your testimony, there was one white person, correct? There was one white male involved, yes, but you are not indicating Mr. Doles was that white person.
That
Can
was
you give
the
us a
first trial or
reference?
the second?
That was the second trial, and that was volume 27, page 180.
Okay, thank you.
Which I believe that would be enough rationale just for them to be able, and particularly that Mr. Doles only did not have actual driver's license, which is a violation enough to warrant them. Not that that would be the significance enough, is still determining who were the drivers and whether there was someone that might be implicated within the robbery the day before. To move on, and again, that's distinguished from Ruiz and Diaz, which was the one with the ladder. This obviously was a robbery. It was much more than a loose ladder that they had to fasten on.
Moving you to consent, can we say a consent is valid when someone is basically told they have no choice?
Well, I mean, I believe that, obviously we believe that we have both factors, not only because we could get into the scale, but we also do have the consent. He asked if he had to, he explained to him the situation of how, the officer explained to him the situation as how he felt it. I believe he still has the freedom to say no if he wants to. I don't know why he would not be able to say no if he did not want to.
Well, a consent has to be knowing and voluntarily given. And when you tell someone, can I search your car? And I have the right to search it anyway, but will you give me your consent? And didn't he ask him several times?
There's two, both in the prelim and then in the trial, the mistrial, this was discussed. And he said in the mistrial, having the digital scare in the rear, and I think both times he said, knowing all the factors that he lay, because of coming from the house, because he stayed at the house the next overnight, Doles did all this, that he felt he had enough to reasonably search.
I understand that, but my question is when you tell the person possessing the vehicle that you have the legal right to search, and then say, well, will you give your consent? And he says something to the effect, do I have to? And he says, well, I think I have sufficient to search. And he goes, do what you have to do. How is that a knowing, voluntary consent to search when they're basically led to believe there's no choice?
Well, I understand what you're saying. What I'm saying is you could say no whenever you want to say no. I believe he still had the option. Again, he's limited. I believe the statement,
Well,
the
he
way
could,
the
he
officer...
could start the car and drive away too, but he's
Yeah,
probably
correct,
going to get
correct.
shot. But we're talking about what's a knowing and voluntary waiver of your rights.
And again, the answer was, do you have to, the officer answered, he said that Doles asked, do I have to, in referring to the search of the vehicle, and the officer responded to him, no, I did not have to, but then I insisted that the search would remove any contraband from his vehicle. So I agree that he's in a predicament of whether he can, in thought process, my still argument would be that he could say no at any time. But then I would look at State v. Sanchez, Laredo, which would be looking at the totality of circumstances and fair probability that contraband would be within the vehicle.
That's your probable cause with the exigent circumstance, the automobile exception case.
Right, State v. Overton, exigent circumstances of a moving vehicle, mobility of the vehicle, you would lose evidence in that counter. And then I would argue the fact that not only did they find the scales, but they had just came from a known drug house. There were known drug users within the vehicle. That Doles had admitted that he had stayed at a drug house the night before. Would all lead to the belief that there would be more drugs within the vehicle.
Is that true absent the scales? Or the digital scale, I should say.
I would argue that it would be with the amount of activity, knowing who they had, Mr. Schmidt, knowing that Mr. Schmidt was a drug user, knowing that they came from a drug house, a known drug person was leaning into the car before it pulled off. From there, knowing that they had just came from a drug house overnight in the last 2 days, I would argue that all those factors, in and of itself, even if he did not reach in, but I would also note that all those factors would also believe with the training experience of what a scale was. The officer repeatedly in different testimonies said that that object was something that he knew to be scales. Now,
Can I take you to that point? And I'm looking at the Court of Appeals opinion. And the opinion says that the officer immediately and correctly believed the object was a digital scale. Did they just get that wrong?
I don't believe so. Just, I mean,
So
there is the one statement that he made that I didn't know what it was.
Right. So how do we reconcile those two?
And I understand that. I understand that that one sentence is what holds on to it. And what I would firmly believe is that he knew it to be scales from his training experience plus all the other circumstances. Because one of the things that the appellant holds on to is the fact that scales are just legal. And circumstances and almost...
So your argument is kind of like he said, I knew it was scales, and then when I opened it up and looked at it, I really knew it was scales.
That would be my argument,
Okay.
because he knew what the object to be, but when the way the questioning was asked is, were you 100%, he didn't ask it in that way, but were you 100% certain it was scales? Well, no, I didn't know because I had to open it up. But with my training experience, all the exigent circumstances surrounding the stop, and the fact that, he was removing someone that he knows to have drug activity or be involved in the drug world, be sitting next to that item that looked to him from, all his other experiences to be scales. And I can tell you, many of our drug paraphernalia cases all generally are scales that someone keeps, so it's not an unusual item for them to see. So I do see that.
I'm trying to recall the district court's ruling on what he said about the scales. Can you refresh my memory? Did he make a specific finding about that evidence?
I can't recall that.
Okay.
I'm sorry.
And I would also like to ask if you believed you argued consent before the Court of Appeals?
That was one of the issues, the consent to search or the consent.
Consent to, yes.
Yeah, both those arguments.
It appeared to me that it was mostly a probable cause with exigent circumstances. I see only a very passing mention of consent.
That's probably a more accurate portrayal of what the argument. There is a line within it that discusses the consent, but
and you believe that's enough to preserve it?
Yeah, it was mainly we had probable cause regardless, but if you don't, we also had consent. Was the way the argument was.
Okay.
And do you recall offhand whether that issue was brought from the Court of Appeals for us to review, even though the Court of Appeals had not addressed it?
When preparing, I didn't note it in my article, but my attorneys made sure I was prepped on it, so I don't know off the top of my hand without going to review it, so I'm sorry.
Very well. Any further questions?
Yes, I have one. Was there any significant difference in the evidence or conduct of the second trial from the first trial?
And what do you mean?
I mean, you retried it.
Did we do the case the same way we did
Yes.
the first time? Pretty much. Yes, you are.
And so really the only difference is that the Taha kind of instruction was given.
Correct.
So you have one mistrial and one conviction. The only difference is the Taha. And so how does that fit into the clearly erroneous calculus?
Well, that's a good question. I believe that Taha, it differs from Allen because Allen was a case where they're trying
That
to...
isn't my question.
Okay, no.
My question is impact.
Well, I would say that, any jury is different depending on the same day. So that's kind of the thing that I believe.
But how can we say that I mean, I'm sure my colleagues will say it wasn't error, but if it were to be error, that, how can we say that, it's not clearly erroneous, or that you've, can show
I
us?
believe what is said in that instruction are clearly facts that matter. I understand what you're saying is if one happened and another happened, but I think that's more than a coincidence than.
That's post hoc ergo propter hoc after this because of that?
Yeah.
Okay, thank you.
Any more questions? Thank you, counsel.
Thank you.
Do I have permission to bring up my cellular phone? It's where the record is.
That's fine.
Thank you. I just didn't know I'd be using an electronic device.
As
May
long
it please the court.
As long as you're not tweeting while you're up.
I don't think I have the focus for that, but I'd just like to address a couple of things Mr. Thompson said in his argument, but I'll begin by answering your question, Justice Nuss, about whether consent was presented in the petition. It wasn't. It was argued before the Court of Appeals. The petition focused on what the Court of Appeals did wrong. Since the Court of Appeals did not reach consent, there was no critique of their analysis of consent. So that is the answer to your question.
And in your view, what does that mean for us?
Well, it creates a preservation problem. I don't know if it creates a bar to considering the issue.
Does it create an abandonment for the state when they didn't pursue it?
That also happened below. So that's yet another procedural conundrum.
If we decide we can address its merits, do you think we have enough to do so without the Court of Appeals having done so in the first instance? Or is it a situation where we would need to remand to the Court of Appeals for consideration of that issue if it needs to be reached?
I think you're in equally good a position as the Court of Appeals to make the determination, since this wasn't a case where the district court made any findings about the validity of the consent. So based on the record before us, I think you're in equally as good a position, since it's a de novo. We're not disputing the facts of the consent, essentially.
Thank you.
The question about whether the white driver issue came up in the second trial, I heard Mr. Thompson say that was on record volume 27, page 180. Is that correct? If that's what he said, I could not find it while rereading the testimony. I don't believe that it came in at the second trial.
But we've got the record.
So you
it either
can,
did or
that's for
didn't.
you.
If tell us, if it did come in, what does that mean? And if it didn't come in, what does that mean?
If it came in, that gives the officer slightly more suspicion to continue the detention than otherwise. Though, of course...
Why wouldn't it, kind of, sort of, why wouldn't it? Absolutely, if he identified the car as being strikingly similar and a white driver and there was a white getaway, why couldn't he have reasonable suspicion to detain that driver to ascertain whether, to investigate the robbery?
Your Honor, I think he could. The problem is that's not what he said. He said, I think in a circumstance, if the officer had gotten up and said, well, I knew there was a white getaway driver, it made me suspicious that one of the men in the vehicle could have been that getaway driver, so I continued to detain them. But what he said was, I saw them and I had reasonable confidence they weren't involved in the robbery. So to me...
When was that testimony? Was that at the second trial or was
that was at the preliminary hearing.
Okay.
Those questions were not explored at the second trial. Then there was a question posed about whether there were probable cause and exigent circumstances to search the scales container. So assuming that the plain view doctrine did not apply,
Well, let's take it by steps.
Okay.
Okay, the officer removed the passenger with a warrant,
Right.
observed this object on the seat.
Correct.
What does it take for the officer then to enter into the car and seize that?
He would
Does
have to.
to have probable cause to believe that the car contains the fruits of any crime at that point in order to seize it? Or does he have to just have probable cause to believe that it's a scale, which then could give him probable cause to believe that there's drugs to search?
That's a good question, because I think it touches on the plain view doctrine would theoretically have given him probable cause to search the car if he had actually
No,
realized.
we're still at the first step. What did he have? What had to happen, or what state of mind did the officer have to have in order to enter into the car and grab that scale?
I think he had to have probable cause that
For what?
specific crime was being committed.
Okay.
Um,
And that there was evidence of the crime.
and that there was evidence of the crime in the car, because otherwise he wouldn't have had lawful egress into the car, because there's the 3 steps of the plain view doctrine, which is that the incriminating nature is readily apparent, that you're in a lawful point of access to view, which he was, and that obtaining the object itself isn't a trespass. And here, reaching into the car, it wasn't like he had a warrant to search the car and then came across this in plain view. Therefore, to actually seize the scales themselves, he would have had probable cause. And at that point, he wasn't sure they were scales and didn't believe he had probable
So you're
cause.
saying the plain view doesn't work for 2 reasons.
I am.
One, it wasn't immediate. The incriminating character wasn't immediately apparent. Second, he inside the car, he wasn't where he had lawful right to be, even though he had arrested the passenger.
Correct.
Does that impact that?
Well, theoretically, there could have been an argument about search incident to arrest, but the passenger was arrested for failure to appear. So there wouldn't be evidence of a failure to appear in the car. So there wouldn't be a destruction of evidence question. And there was no testimony that he thought that it was a weapon or anything dangerous. That might also have justified reaching in the car. So there are reasons that he could have gotten in the car after the arrest, but they didn't exist in this case.
What about the exigent circumstances that Mr. Thompson talked about?
Well, that also doesn't apply to the scales, because even if this court finds that the plain view doctrine justified the seizure of the container of the scales, actually opening the container should have required a warrant under Horton. Because even if you can see something in plain view, like if you believe the container contains evidence of a crime, you can seize the container, but once you've seized it, there are no exigent circumstances. So the Court of Appeals said you could open the container based on the automobile exception, but that's a misapplication. You could take the scales because of the automobile exception. You don't want them to drive off with it. But you couldn't actually open the scales container without a warrant, because they're not going to go traveling on their own. So the scales themselves are not an automobile. So the opening of the container should have been done pursuant to a warrant, even if this court finds it lawfully could have been seized from the car, which of course we dispute.
Counsel, you're well out of time.
Yeah, I am.
Do you need about 15 seconds to wrap up?
We would just ask that this court reverse Mr. Doles' conviction, and that it finds that the evidence was improperly admitted.
Okay, do we have any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. Court is now